Disputes. I'm going to talk in two, but to divide what I'm going to say in two bits. First, I'm going to focus on the UK and where we've got to and why it's dysfunctional. And I suspect in some way that's really a sort of buttress for Frank's talk along the lines of why can't we have something like the Canadian Ombudsman. And then secondly, a reflection on why what we have in the current new directive and are likely to have going forward is almost as depressing as what we have at the moment. Before I started looking at other countries, I thought, well, I can't do international, but I can think about, of course, the students of the Go-Between by L.P. Hartley will recall that the past is another country. They do things differently there. And so I was reminded that 20 years ago, I wrote an article called Prospects for Establishing an Effective Tender Challenge Regime Enforcing Rights Under EC Procurement Law in English Courts. And I said there, the effectiveness of the system turns on the availability of interim relief. The author remains unconvinced that the remedies directives will have a substantial impact on ensuring compliance. My provisional proposal is that a more effective means of institutional enforcement should be put in place on a national basis. A body or bodies established in each member state could act as investigator and prosecutor with a role not unlike that of national competition authorities, etc., etc. Well, none of that's happened. We've ended up with a system which is said by everyone in the UK to involve far too much litigation and is said by the Commission in Brussels to involve much too little. In Brussels it's said that our relative lack of litigation for the size of our public sector demonstrates that we're actually deficient and that we must be hiding something. I think there are a number of conceptual problems, and I don't have time to go over all of them. One problem, picking up what Steve Schooner was saying this morning, is that we are focused on bid challenges. Our entire system of dispute resolution is focused on bid challenges, or has been, and misses out the connection with design issues. Although theoretically you can use our challenge procedures to deal with bid design issues, in fact, it's very rare that anyone does, although it's beginning to change. And we don't have a connection through to performance issues. We're now seeing performance issues brought into the process of bid selection and bidder selection, but we don't really have any proper connection between performance disputes and bid challenge disputes. And we don't have any very good models because, of course, the EU's own dispute resolution procedure for dealing with procurements by EU institutions is worse than ours. Although it has a lot of cases, they seem to operate in their court system with an invariable rule that it doesn't matter how bad an EU institution behaves, it won't have to pay compensation. And that is almost an invariable rule. So we don't have, as it were, a lead from our central judicial system as to how we might do it better. We have to deal with we've ended up, for historic reasons, deciding that we'd use our existing court structures and adapt them to procurement disputes. Now, Ireland took a superficially very different route, but I think has ended up in exactly the same sort of confused place, trying to make the court structure work in disputes where it just doesn't work terribly well, because we end up stuck with the same sorts of problems over choice of remedies. We end up, because of the way EU law is structured, we end up having to make damages available. Damages include loss of profit damages, and the common law process gets stuck into that and says, well, as long as damages are theoretically an adequate remedy, that would be the primary remedy. And we get ourselves into quite a tangle as to what should or shouldn't happen by way of choice of remedies. Indeed, as I've written else in an article a couple of years ago, one of the problems is that if damages is too effective, we actually undermine the ability to get decent remedies in terms of actually fixing contract problems as and when they arise, because the courts have historically taken a fairly, it's not even fair to call it a conservative view, they've taken a standard common law view. Well, if damages will in due course be adequate, why would I interfere with this process? We're beginning to see a change but it's not yet bedded in at appellate level. Perhaps one of the most important and encouraging judgments here is a judgment of Mr. Justice Coulson in a case called Cavanta last year. It's important not so much for its decision, because in many ways it just follows the standard line of authority, but for the first time he actually says, and this is quite radical, that compliance with the law should actually be one of the factors when you take into account when you decide whether or not you should simply give a dissatisfied bidder damages, or whether or not you should actually tell the awarding authority, no, you actually have to fix the problem that you've created. One of the reasons why we have got into this problem is that we have a tangled mess of criteria about how we should actually decide these decisions. If you find we're stuck in the court system, and the courts can work relatively fast by their own standards, and they have the advantages of having heavy disclosure procedures, and so we can get a lot of information at an early stage, but we're stuck in this process of balancing public interest against the normal interests of litigation, in circumstances where in the UK we have created a procurement system which is apparently, I haven't seen the details of this survey, the third slowest in the EU. So that the answer in almost any case, quite independently of what the court system does, is to say, well, we can't re-tender, we can't fix the problem because we need the contract, and if you stop us from doing it now, it will take us X months to do it again. And this is this may be a truthful statement, but that's because we've created this monstrous procurement system which is substantially less effective in terms of pure time than most of our EU partners. Quite how we got there is a tricky situation. So, without going into the sort of the gory legal technical detail, I think we have ended up with a system which does not work terribly well for anyone. It creates the threat of litigation which has almost encouraged a rather half-hearted approach to the law by the public sector. You see words used about legal compliance in public procurement by public sector officials which you would not expect to see in other areas. People talk about complaints about overzealous compliance with the law, flexible approaches to the law. In most other areas of the law, you don't take a flexible approach to immigration law. You don't take a flexible approach to habeas corpus. You apply the law. But we've got used to a culture in procurement that because the threat of the remedy is a hindrance, the public sector has got itself into a mindset that actually non-compliance isn't quite so bad. And on the private side, it's got itself into a rather depressed view that it doesn't really matter what they do, and unless you're very big and you really are prepared to rattle the government's cage, not a lot can really be done. To be fair, I think this is actually what was originally intended. I think we were intended to have a non-functioning system. I think when the choice was originally made 20 years ago as to how the UK would implement remedies, the decision was taken that if we put in place a tribunal system or an ombudsman system or whatever alternative system we might have had and could have had compliant with the directives, that would simply have encouraged complaints. And the government view at that point, both here and in the Republic of Ireland, was let's put it at the highest level we possibly can because that will dampen down complaints. And it worked for 10, 12, 15 years. The problem we have now is we've got a system which has sort of broken down and is now, it needs fixing and we need something new. So, there are some signs of change. I think the mystery shopper scheme, we have a scheme in the UK where the Cabinet Office you can ring them up on a non-binding basis and say, I've got a problem with this procurement, please will you look at it? And if they produce every 3 months a summary of the cases they've dealt with. They're quite interesting cases, some of them. and sometimes the Cabinet Office is able to get some sort of resolution. But there are a number of limits. Firstly, the Cabinet Office is not a neutral party. The Cabinet Office is the government department in charge of purchasing policy. It is always has an interest of some sort in the procurement. And that is sometimes reflected in the outcomes. Mystery shopper, the procedure is non-binding. Well, that's fine if it can get an outcome, but it's non-binding and has no relationship with the court system, so that if you've used up the time in the mystery shopper process and you then don't get the outcome you want and you do want to go to court, you're out of time and your limitation period is used up. So it's actually, and the mystery shopper process does not work. They make it fairly plain that they won't use the mystery shopper while you actually have ongoing court proceedings. So you really have to make your choice between a soft process which will not, in fact, has no ability to give you any positive outcome in this procurement, but merely to help you going forward, or dealing with the current problem in the current legal proceeding. Oddly, in the NHS, we have put in place exactly what we've said would be completely impossible in any other. We've always said we would not have a specific procurement monitoring system. We would not have any monitoring tribunal. We would not have any conciliation tribunal. And that's what we have in the NHS, because under our new procurement arrangements for healthcare services, Monitor does exactly that. And if you read the NHS procurement regulations for the procurement of healthcare services between GP commissioning groups and hospitals, the system looks exactly the way you might expect a tribunal system to work. So whatever this great point of principle was, that we shouldn't have a non-court system of dispute resolution, can't have been quite so important.